Peter Mutembei. Peter. Francis.
Now, Peter, today you have to sit on that side. You are the first one. Yes. Yes.
Francis Mwando. John Mwandi Kamau.
Yes.
Joseph Kamau Buglo.
Your hooks off. Your hooks off. Yours as well. You can maintain your masks, but move those things from the head. I need to understand. Now you can see. Mr. Wenge, for
I represent the first accused together with Madam Somali.
first respondent.
I'm present, Your Honor.
4.
Okay. Prosecution.
We have a guest
Oh, we have a guest.
from the country.
The first name, kindly.
Cohen Amanya.
Okay.
No, C-O-H-E-N.
Yeah, on behalf of my court.
The prosecution.
Your Honor, Mr. Sani.
As much as they tried to stick to the law, both the respondents and the prosecution counsel veered into the facts of the application slightly to support their arguments. It is the respondents' contention that the IAU cannot file the application before the court for lack of jurisdiction or locus standi, that the jurisdiction of the said unit is limited to handling matters that should be dealt with internally and should not be entertained within the public domain and especially the courtroom. Section 87(2)(a) of the Act provides that the IAU shall receive and investigate complaints against the police. The question that begs for an answer is, from where is the IAU supposed to receive the complaints? The answer is found in Section 87(4) of the Act, which states that the unit shall investigate and hear complaints from members of the service or members of the public at the direction of a senior officer, on its own initiative, or on the direction of the Inspector General, or at the request of IPOA. Can it therefore be said that after investigating the complaints and misconduct against police officers, the IAU cannot take such officers to court? I do not think that is the correct position. The IAU is a unit comprised of police officers, right from the director to others of lower ranks. Section 87(2)(a) clearly grants the officers powers to investigate complaints against police officers. It is only after investigations that the unit may conclusively decide whether a matter should be handled internally, that is administratively, or whether it should go through the criminal process. The object of investigation is misconduct as stated by the applicant, which relates to the discharge of the duties of the for respondents. It has been argued that this matter is politically motivated. However, no such evidence has been placed before the court. Further, it has been argued that the application is an abuse of the court process. I have been forced to go through the application not to examine the merit, but to examine whether on the face of it, there is a legitimate complaint that gave rise to the application before court, and the answer is in the affirmative. Conclusion: AU must cede their authority to investigate such criminal breaches? I do not think so. The IAU can conduct investigations, then make recommendations which they can pass to the IG or the DPP. The Black's Law Dictionary 960, the 4th edition, defines investigation as the process of inquiring into or tracking down through inquiry the action or process of searching minutely for truth, facts, or principles. In Brotherhood of Railway and Steammanship, Clerks, Freight Handlers, Express and Station Employees versus Association of the Benefit of Non-Contract Employees, it's a U.S. matter, the court stated that an investigation is essentially informal, not adversary. It is not required to take any particular form, in which the court said investigations are informal, proceedings held to obtain information to govern future action, and are not proceedings in which action is being taken against anyone. Flowing from the above, It is to be understood at this juncture that the applicant has not made a decision to charge the respondents, which action is outside their mandate. The applicant is only asking for court's intervention to conclude investigations. It is my view that this is the scenario obtaining in this case. The respondents have submitted that the IAU cannot investigate the offense of abduction. I do not agree. The unit can investigate, but upon completion, they must hand over the outcome to the IG or the DPP. To my understanding, the application before court is meant to facilitate the investigations and cannot be said to be an abuse of the court process. Should the applicant dare exploit the phones of the respondents without a court order or subject them to DNA without a court order, that would be a violation of the respondents' rights, and whatever evidence is obtained would be inadmissible. Finally, I've gone through the authorities relied upon by the prosecution and find that the same are distinguishable, hence not applicable in this case. For the foregoing reasons, I find the preliminary objection to be unmerited and it's hereby dismissed. I find the application dated 24th October is properly before this court. Those are the orders of the court.
Now,
I
Mr.
do
Onge,
appear.
Mr. Onge, you were appearing for which
I
respondent?
think my colleague appears together with me.
Mislead my seniors. There is a need in which it makes constitutional sense to persuade the court to grant us time to file responses. Your Honor, you've been approached formally.
Add that considering the nature of the right that are about to be infringed, in our view,
We have persons who have not been found. The disappearances is what is being investigated. Your Honor, the victims disappeared on 22nd and 23rd of July, and the police has been investigating that matter. Those are, I think, close to roughly around 3 months, around there. Your Honor, the family is agreed, and the family is here. So, Your Honor, as we take the time, also we need to look at what the family is feeling, because they can't get their beloved ones. Both the Codemas, that is and the two Indians. We beseech the court that let everyone's right be respected. We don't have any issue with the respondent or what. What we are only interested is on the fact finding and the whereabouts of the victims. That's all. There is nothing here we are all about. The politics, the sideshows, the everything.
You're not saying that is his instructions. This court is after protecting innocent people and also getting his clients. Everybody is looking at the court to get the truth. It's not about victims only. They might be fictitious victims that don't even exist.
Okay, this is what he's saying.
Your Honor, the Supreme Court addressed
You know, we will be getting it. Yes, we have a digital library here. They will get the quotation.
Now, kindly give him time.
Give us the citation.
The whole profession. Yes, allow him time kindly and be very brief.
Your Honor, as my colleague makes
Oral submissions. Now we will have to agree on the time right now. So long is.
It is a police work.
Yes.
The police's mandate under Article 245 is to investigate. And they are investigating. They are only coming this court to ask for you to allow them investigate. There is no accused person in the dock. And that's why they are called respondent, which is a civil term. They could be accused number 1 or accused number 2. They are before you through a miscellaneous application, a civil matter, not a CR matter. So our suggestion and our position is that by law, the victim has no role in this matter. The victim will go and record statements with the police.
Inspector Veronica Gitahi, a Court of Appeal decision, as well as Lendrix Waswa, a matter which went all the way to the Supreme Court. The two courts have pronounced themselves boldly that the role of a victim in the criminal justice system is not passive. Victims no longer sit around like robots waiting for the prosecution counsel to do everything. Without victims, there would be no criminal cases in courts of law. It should be noted that the matter before court is not one of a civil nature as submitted by the respondents' counsel. The investigations are criminal in nature insofar as they seek to unravel the mysteries surrounding the disappearance of 3 victims. The victims' family are therefore permitted under the Constitution as well as the Victims Protection Act to make interventions within the parameters set out by this court. It is their right to monitor the investigations and raise any concerns with the police as well as the Office of the Director of Public Prosecutions. But the moment they land in court, they have a right to participate as long as their participation does not inhibit or impede access to justice. They are not, for instance, supposed to frustrate the prosecution in the discharge of their duties. Neither can they take over control of the prosecutorial duties. As stated above, their participation is limited to giving views. This participation continues right from when a suspect has been arrested to the conclusion of a trial until the appellate process is exhausted. I would therefore hold that the victim advocate's submissions were within the parameters set out in both Inspector Veronica Gitahi as well as Lendrix Waswa, and dismissed the application by the respondents' counsel. Finally, the respondents' advocates have sought some days to file a replying affidavit. That application is not opposed. The respondents are therefore granted 2 days to file their response. This matter shall be heard on 28th, Friday at 9 a.m. Those are the orders of the court.
Section 87 of the National Police Act, the internal police service, internal unit cannot. The court has dismissed that application and said the internal police unit has power to investigate. After investigation, it will give the report to the Inspector General, and the Inspector General will forward that report if there is any criminal culpability to the DPP before our clients are charged. We are not satisfied with that decision, and we have sought leave to appeal, and we shall be moving to the court, to the High Court, by close of business today once we get the certified copy of the ruling, because this is not the proper interpretation of the law. But we respect the decision, that ruling by the court. Number 2, our clients have sought time to respond to the application that was filed. Reasons being that among the orders being sought is their DNA, which is a serious affront on the right to privacy and the constitutional right for somebody to be dealt with in form of dignity. So we have raised that. We have been given 2 days. We will file our responses very conclusively, where we shall be arguing that those orders are not only legal, they are unconstitutional, and they are meant to humiliate and embarrass our clients. So that is the issue. We shall be before this court on Friday at 11 a.m. to argue that application. But meanwhile, before that, we shall be moving to the High Court today, and therefore by tomorrow we shall know whether the High Court has agreed with us, or if the High Court has not agreed with us, we have full instructions to move to the Court of Appeal and to the Supreme Court, because this to us, our clients feel, is political witch hunt, is purely malicious. They are being targeted because of politics, and we will defend our clients to the hilt. So that is what transpired today